everybody, you're very welcome back to Law Hero. My name is Jen. I make videos about the law. And today we're looking at contract law from autumn 2023. Now, I actually made another video about this and it got deleted. And it starts from question 3. So I'm actually going to really go through question 1 and 2 quickly. Because I spent so much time, from question 3. So just really quickly, question 1. On the paper, you're advising Carol, and basically she's been in an informal relationship as to landscape gardening. Now, what I said in the last video I made that got deleted was that she has a contract to fulfill here, and yes, it's being terminated. The problem is she's in a business, she's dealing with another business, and she has no written agreement which would usually dictate the notice period. So here we're kind of relying on this business to be reasonable with her, but at the end of the day they actually don't have to be, because it's a very ad hoc kind of relationship. They ask her to come and do it, and they pay her. The only other thing she could rely on is promissory estoppel, because obviously this money she has relied on is going to be going now. But I think it will be difficult for her to prove the assurance piece. She can show the reliance and detriment piece, but the assurance piece is going to be difficult unless she has anything in paper that would show her, that there was an assurance that this would be a going concern. That will be a difficult limb to fulfill. Also, it's been 7 years, so a court really wouldn't look favourably on the fact that she hasn't formalised the relationship in that time. So I would say, Carol, there's little or nothing you can do about this. And also as well, the fact that this is the second part, by the way, I'm jumping ahead. Also, the fact that the hotel can say they're paying at a lower rate, they can argue that the contract, it's just not economically feasible for the contract to be performed at that rate. So sucks for her. So the first part then is around part payment of a debt. I'm sure you'll all be fine with that. Then then Carol comes back after paying the debt and says, I want my $4,000. And the question is, is that okay? So on Carol's behalf, we could probably argue that, that she was under duress at the time to take the $6,000. And that, he had promised her $10,000. He's a businessman himself. Unless he's actually gone into personal insolvency, there's no reason why he shouldn't pay up what he owes her. Be my question 1. And then question 2 then was around, is a very interesting question around whether there was a contract in the first part. And I suppose we go back to first principles and we say, okay, they were in negotiation, they negotiated around price. But I think when I was, applying the law to the facts there, I said that it's basically like, will you buy bumper haul, will accept lowest price, and then there was radio silence. I just don't think acceptance of the offer was communicated. I don't think the smiley face is up to it. And I think that the fact that a big part of the contract wasn't agreed, which was the delivery schedule, I would argue that Tom isn't in a good position here to enforce this contract. I would actually argue that there was no contract and that they were still at the negotiation phase, and then I would talk about that Canadian case, but I would differentiate it on the fact that it was a thumbs up to a contract that had been written. They were sending the contract and going, do you agree with this? Which shows that the fundamental terms have been agreed upon, whereas here they weren't. And in the second part of that was just classic frustration. Question 3, which is future Jen, who's going to talk about the Consumer Protection Act 2022. So let's get this very, very clear about the law. So under section 15 of the Consumer Rights Act, there are certain conditions which a good must be in. So it must be fit for purpose, fit for all purpose it's usually used for. We call that conformity. Have the qualities and features of similar type products. fit the description, type, quantity and quality used in the sale, be durable and of expected quality for normal use, meet the quality of any sample or model you were shown, match any ad or label, have the necessary functionality, compatibility, interoperability and other agreed features, come with all the accessories it says it's supposed to come with, have the correct instructions, have the spare parts covered in the contract, be correctly installed by the seller if applicable, have information on digital updates if it's a digital product, obviously. So those are the subjective and objective requirements from section 17 and section 18 and section 19, which is the installation of the goods. Okay, if this section 17, 18 and 19 are not adhered to by the seller under this act, you are entitled to certain remedies under chapter 3, section 23, 24, 25 and 26, which are usually called repair, replacement, refund, price reduction or short-term right to cancel. Remedies apply whether you buy at full price, a reduced or discounted price, for example in a sale, or you buy a second-hand good. That being said, sometimes you are restricted by a seller's shop policy or terms and conditions, which should have been brought to your notice at the point of sale, for example, by way of a sign. For example, no refund on sale items, only exchange, or sometimes you're told that at the point of purchase. Or for specific garments, for example, swimwear or underwear, or for example, like wetsuits or something that if it's used once kind of becomes unsellable from the point of view of the seller. They have a justification in doing that because that's a proportionate, that is proportionate and it makes sense economically that you would do that. And that's why you do not have an automatic right to a refund because you have changed your mind. If there's nothing wrong, and that's, we only have a right to remedy when there's something wrong. And when we say there's something wrong, it means that section 17, 18 and 19 have not been adhered to by the seller. Otherwise, you have no right to return the good. And whether or not you get a refund depends on the terms and conditions of the seller's policy. But as we know, for example, Primark, they have a very good customer experience, or CX, and they will allow you to return the goods within a certain period, and they will give you a cash refund. They can do that because they're a bigger retailer and they have the economic means to do that. But for example, if you go into a small boutique, you'll usually get like a credit note, for example, because they don't have the same kind of income. So if you make a return, it's going to be much more difficult for them to make it right. They would much rather keep the money in store, so that's why they give you a credit note. For example, Ironman do this. Rather than giving you a refund if you're not able to do a race, they will give you a race transfer because they want to keep the money in the group, and that's very annoying for a lot of people because they're not going to get their money back. And I'm sure there's like X amount of examples you can think of off the top of your head where you don't get a cash refund, but you may get a credit note. But, you actually get an extra right when a product is not bought in a physical shop, called a cooling off period, which allows you to cancel the agreement within 14 days of receiving the goods, and you can get a refund for that. This of course doesn't apply to certain purchases like personalized products which have a short shelf life, and I kind of mentioned this earlier, products that cannot be returned for health or hygiene reasons, leisure services like hotel bookings, car rental or concert tickets, or passenger transfer services such as bus, air and rail. Okay, so applying the law to the facts here, we have a raincoat that is advertised as being waterproof. So therefore we would argue on behalf of Mark that that the good is not in conformity with the contract under section 15. Then we would argue that even though it's on a discount, that this section still applies. That being said, though, the shop policy said there's only exchange on sale items, which is a replacement. But that would certainly be adequate and proportionate remedy for the buyer. Okay, so the second part says, by the end of July, poor weather means Mark has given up on hiking and he goes back to playing video games. He buys a new online game called Buzzcraft from a software company, but from the beginning he finds the software glitches and it won't save any of his changes or moves. So we know that digital products now come within the realm of the Consumer Protection Act, and the same kind of subjective requirements and the functionality piece and the conformity piece would apply to computer games as well. When he contacts the seller, they send him a link to upload software to fix the problem. But they tell Mark that this is a €10 fee and an upgrade. So we already know that anything that assists with the interoperability or upgrade of a product has to be included in the contract and should be free of charge. You'll also see that under section 17.4, any spare parts and after sales service must be available by the trader where representation has been made and for a stated reasonable period. Here he bought the game in July and he's saying from the very beginning there's been problems. Even where the trader sells third-party goods, the responsibility to provide updates is placed solely on the trader. So this will be here with the seller of the goods. So the remedies here would be repair or replacement, subject to either it being possible for the trader to carry it out or it being disproportionately costly on the trader to carry it out. Section 23, 24 and 25. So yeah, I would say under section 17 that the subjective requirements haven't been met. And he has a remedy for that, in that he does not have to pay this €10 fee. Question 4 is actually quite similar to question 2, but in this case they seem to go a little bit further because they actually get to drafting a contract. But there's a pretty heavy hitting exclusion of liability clause there, and Celine doesn't read the document. So there seems to be some kind of misrep there around sulfur being in the hops, which we know we can sue for misrepresentation, which will allow us to void and claim damages if the misrep was fraudulent or negligent. Question 5, we're advising Jane around installation of a jacuzzi and compensation for breach of contract. I'm not going to go down to that one either. Question 6 relates to anticipatory breach. She's meant to start recording on a certain day and doesn't. Reneges on the promise. Also the fact here we have a minor But as we know, in certain cases, there are certain contracts which are of necessity or beneficial employment. It seems to be here. Usually you would have an agent for a singer. Question 7 is advise cold store on a delivery contract here. And this just seems to be around a penalty clause, which is fairly straightforward. And question 8 is an essay question around the contractual principles to protect people who provide guarantees and securities to financial institutions. So you would use arguments like non-a factum, it's not my contract, and undue influence to try and avoid those contracts. And also the principles around, not getting legal advice. That would also be a way to show a lack of understanding of what you're signing up to. So yeah, all in all, I thought it was a fine exam. Some new consumer protection stuff in there, but I actually think that'll be fine going forward. It seems to be just the basic stuff, nothing too complicated. Anyway, I will see you in the next one.